It appears we've got Mr. Lugo, Ms. Norse, and Mr. Lord. I see you now as well. So we are ready to go forward. Mr. Lugo and Mr. Lord, will you be dividing your time?
Yes, Your Honor, we've conferred about this and we're going to be.
Mr. Lugo, you may need to pull the microphone closer or lean in further because I could not hear you.
Okay, yeah, I was being kind of low too. Yeah, we have conferred, we've divided the time, 13 minutes. I'll make the initial presentation. Mr. Lord will have 4 minutes and I'll reserve 3 minutes for rebuttal.
Very good. And I'm going to ask you to speak up or pull the mic closer because it's still fairly faint.
Okay.
All right, you may proceed, Mr. Lugo.
May it please the court, my name is Ezekiel Lugo and I represent the appellant Jessica Lynn Turner. At this time, I would like to reserve 3 minutes for rebuttal. This morning, we request that the court reverse the order denying the motion to enforce the settlement because the plaintiff's civil revenue notice offered to settle, quote, any and all claims, unquote, in exchange for policy limits. And the insurance company, in fact, did that. It tendered those policy limits in accordance with the terms of the civil remedy notice.
A civil remedy notice is not served on a party. It's served on the Secretary of State or the comptroller. When has that ever been deemed an offer to settle or a demand for settlement? It's a statutory vehicle.
Yes, Your Honor, it is a statutory vehicle. The terms of the statute, section 624.155, subsection 3A, talks about this being a written notice to the insurance company as a condition precedent to the statutory bad faith action. But subsection 3C talks about the effect of sending this notice. And it says that the cause of action will not lie if the insurance company within 60 days of the notice cures the particular violation or pays the amount due under the policy. And the case law in Florida, the Florida Supreme Court in the Tallet case, explained that the whole point of the statutory scheme is to allow the insurance company an opportunity to pay the underlying claim, resolve the underlying claim, and avoid the bad faith litigation. So the whole purpose of this scheme is to effectuate a settlement of the underlying claim, and that's what's at issue in this particular case.
Well,
Now,
if that were indeed a separate offer, I'll just take your word for it. Let's say the CRN was a offer. Why did the acceptance make reference to the initial demand of January 30th, 2018?
Your Honor,
If that's a separate independent offer, why would you even refer to the first one?
because there were separate offers pending at the same time, and the adjuster was trying to comply.
So which one did she accept?
She tried to accept all three, both of them. She in fact accepted. Our argument on appeal is that she in fact accepted the offer in the civil remedy notice, because that offer asked that the insurance company provide a check for the policy limits made out to the law firm for the plaintiff, delivered to that office within 60 days of the civil remedy notice. And in fact, that was done. There is no.
So if she accepts the civil remedy notice, why does she need to even refer to a conversation with Jessica, the paralegal, where Jessica allegedly waived the contingency of the affidavits? If the CRN is an independent separate demand, why even make reference to that? Why even make reference to a waiver of affidavits?
Well, this was an adjuster trying to accept this demand.
Well, I understand that. I understand that. I used to deal with adjusters for years. I get it.
The
But
adjuster,
if you're telling me the CRN is a separate and independent demand or offer to settle, why is she making reference to everything that occurred before the CRN? Talking to Jessica, waiving the affidavits, your January 30, 2018 demand.
because she was trying to comply with all of the pending open demands that were available at that point. She was trying to do everything that she thought needed to be done to accept all of the demands that were out there. But the particular offer, the civil remedy notice, does create an offer. It lays out an intent, objectively lays out an intent to enter into agreement and in exchange for performance from the insurance company. And in particular, that language is on the portion of the civil remedy notice that's described as the facts and circumstances giving rise to the violation. The last, I would say, 6 lines or so describe first what Progressive has to do. And then the last 2 sentences say that if Progressive does that, it states, and I quote, "In so doing, it would be a complete, full, and final resolution of any and all claims of Geraldine Taylor, known and unknown, including any and all attorney's fees and costs, as well as any and all alleged damages for any potential bad faith claim stemming directly from the subject accident." Period. Next sentence.
Yeah,
In
but
short-
Mr. Clark clearly expressed and made reference to the January 30, 2018 demand that he made in the CRN. So if that's a separate independent demand, why make reference to a prior demand?
Because this was a civil remedy notice as well, Your Honor, and he was explaining, again, this is under the section facts and circumstances giving rise to the violation. So there are facts here. That section begins, it can be divided into 4 parts. The first part talks about the facts of the accident as the claimant understands them. The second part talks about the settlement so far, and it references the demand. So there is a reference to that demand in there. There is a description of what was included as far as exhibits to that demand. And it indicates that the insurance company did not make an offer to settle the claim. And that is the explanation for why they're alleging that it was a bad faith. There was no attempt in good faith to settle the claim. The third part of this section talks about what Progressive has to do to cure, which is tender the check, made out to the law firm, delivered to the law firm within 60 days. And then the last part says what the consequence of doing that. And that language that I read, the "in so doing, it would be a complete, full, and final resolution of any and all claims of Geraldine Taylor," that is what Mr. Clark would offer in exchange for the tender of the policy limits.
Well,
so,
Mr. Lugo, what's your best authority for the proposition that the CRN is an offer, that it creates an offer and it creates a contract? Because you kept saying it. That was the premise for the bulk of your argument, but I don't recall you ever citing any authority for that basic premise. So what's your best authority for that?
the general case law that talks about what is an offer, the objective standard that's applied to determine what is an offer.
So if I tell you, if I say, okay, if you give me $500, I'll give you, X. And then I go to a third person and say, yeah, I told him if he gave me $300, I'd give him X. And you find out about the phone call, or you're told about my statement to the third party. That creates a contract between us. I told you 500. I told them 300. Now you think all you have to do is give me 300. That's it? I mean, that's a contract between the two of us?
No, Your Honor, the contract would be the original terms described there.
So how is the statement in the CRN that supposedly created the second the second offer to settle of just the 10,000?
Because, Your Honor, the CRN has to be provided by statute both to the department and to the insurance company. And if you look at the end of the civil remedy notice, and you can look at pages 47, and it's repeated on page 96 of the appendix to the initial brief. The very last thing there, it says, after submitting a notice using the system, you must print a copy and provide it to the insurer.
Okay,
The state,
I have to tell you, I have to let you know what I told the state. Right.
Right.
So I would have to tell you what I let, if I told Miss Norse $300, I would have to tell you, I told Miss Norse that you just had to pay me $300. Wouldn't the reaction be, well, you told me $500, you told Miss Norse $300, which is it? Doesn't that at least create a question, and not just, oh, well, we now have a contract that if I just give you 300, we're all set.
Your Honor, the difference between the fact scenario that you're describing and the facts in this case is a statutory scheme that's at issue here. and the case law interpreting the statutory scheme, like I explained. Once the civil remedy notice is provided, there is a 60-day window for the insurance company to pay the underlying claim, resolve the underlying claim. In this case, that was done by tendering the policy limits. The consequence of that was laid out by the claimant herself, her attorney himself, when he stated that in so doing, it would be a complete and full and final resolution of any.
That raises a very good point. Mr. Lugo, that raises a very interesting point. Let's assume for the sake of this argument that we agree the notice is an offer to settle. You have pointed out that the offer in the CRN states that if it's accepted by paying the policy limits, it would be a complete and here's the wording, it would be a complete, final, and full resolution of any and all claims. It would be a complete cure or remedy of the deficiency and a complete resolution of the claims described above. So when the tender is made, there is also a request for execution of a release. Under the facts of this case, why is that request for a release not a counteroffer as opposed to an unconditional acceptance of the offer as made in the notice?
There's two reasons, Judge Silverman. One is looking at the plain language of what you were reading from the civil remedy notice itself. That broad language of it will be a complete, full, and final resolution of any and all claims indicates that a release was contemplated as a
no, it seems to be self-executing. That if you accept by paying us the $10,000, everything is done.
Well, right, Your Honor, but
and so your client instead said, not only do we want we're going to make the payment, but we also want a release. We're not married to the exact form, but we want a release, right?
Right. And that's the second part, that we're not married to that form. But looking at the language itself.
But your client wants an executed release.
Right. And the case law, there is case law out there.
The case that you cited, Earhart, talks about under the facts of that case, that it was implicit there would be a release. But the reason it is implicit there is they say at the end of the opinion, simply put, it would have made no sense for Security National to tender its policy limits if there remained a possibility that it could still be liable for further claims by Earhart arising from the same incident. Under the facts of our case, the notice contains language that did not leave open a possibility that there could be further claims. Isn't that correct?
The notice was, our argument is that the notice included everything. It would resolve both the tort action.
So then a request for an additional release is an additional term that was not necessary to conclude the claims.
No, Your Honor, we cited the Earhart case, but we also cited a case called Mercury Insurance versus Fonseca, where the third district explained that when a release is proposed and there is a statement that the specific form of the release can be discussed by the parties, that doesn't turn an acceptance into a counteroffer. And that is what happened.
That's because under the case law that deals with those kinds of issues, those cases are concerned that there could still be an open claim that isn't finally resolved, and the release is necessary to document that. But in this case, the CRN documents that there will be no further claims.
Yes, Your Honor, it states that, but the release.
Mr. Lugo, just to let you know, you're at the 13-minute point. You can go ahead and respond to what I just asked, but you'll then need to relinquish the time to your co-counsel.
Yes, Your Honor. The argument is that because the language is so broad and full and final, and it made it clear that everything was being resolved, then the release is really implicit in that language. And because there was in the cover letter an explanation that it wasn't contingent on this particular release under cases like Fonseca, it didn't turn the acceptance into a counteroffer.
Very good. Thank you. And Mr. Lord, you've got, let me just make sure I've got my timing correct. You have, I think we marked it down as 4 minutes. I'll give you 5 just to make sure you have a full opportunity to answer the many questions we have posed.
May it please the court, Chris Lord on behalf of the appellant, Vincent Um, Essentially, we adopt everything that's in our joint appellate briefs, Your Honor, and we adopt Mr. Lugo's arguments. If there's further questions, I'm happy to address them or defer my time back to Mr. Lugo.
Well, Mr. Lord, I'd like you to address the last question I asked, which if we agree that the CRN constitutes an offer, the language of the CRN is very clear that if tender is made as contemplated, it's all over. So why should we not consider that the request or insistence on a release be a counteroffer under the facts of this case?
Well, in this case, the big distinction is, which was argued during the evidentiary hearing, Your Honor, was the two separate offers. And in Part A, they asked for the financial affidavits and the release. In Part B, which is the CRN, there's no mention of anything to do with affidavits or releases. So
Right.
by the distinction
So
is
the failure to provide affidavits may not be a problem, but it does seem like that the demand for an executed release in some form, that now seems to be imposing a new requirement for the benefit of your client and Mr. Lugo's client.
Well, Your Honor, I would disagree with that in terms of because of what the terms of the CRN stated specifically, and that the offer is pay us $10,000 to the law office within 60 days, and that will cure any and all effects. By the adjuster taking over, and it's undisputed based on the timeline, the check was taken to Mr. Clark's office within that window. And so that there's full compliance
with a letter that said, by the way, we also want an executed release, correct?
Well, the letter said that, but to say that the terms, if you just, because this is the thing, what got during the evidentiary hearing too, is that got cross-referenced, Your Honor, is the fact is there's two separate offers and they're getting commingled. And the point is the focus.
If we go back to the negotiations relating to the original offer, then the trial court determined that offer wasn't accepted because the affidavits were not provided. The court made a credibility determination as to who was telling the truth in terms of what was said in relation to the affidavits. Seems to me that's going to be a pretty tough argument for you all to overturn. So, either you're relying on the first argument, which there's a problem, the first settlement offer, or you're relying on the CRN, which basically says you tender the money, this case is over. And yet when the tender is made, there's an insistence on an executed release in some form.
Well, Your Honor, I'd say it's over as soon as the $10,000 is delivered to the office because they've complied with the offer on the table.
But the tender was a conditional tender, right? Here's the $10,000 and you need to give us a release. I mean, that seems to me to be a conditional tender.
I disagree, Your Honor, because just based on the CRN as a whole, Your Honor, it's saying give us the $10,000 and then any and all claims, including bad faith claims, are done. They got the $10,000. It's undisputed. So everything's been complied with.
Here's my problem. The Supreme Court of Florida says that a notice sent to the Department of Insurance concerning settlement violation is intended to serve as a basis for the department to assist in the settling of claims and to monitor the insurance company. This is not an offer. I don't even want to take the bait. This is not an offer. Mr. Clark notified the Department of Insurance. He didn't send this to Progressive. Now, Ms. Harvey, this is a prime example of lawyers being afraid to pick up a phone, adjusters being afraid to pick up a phone and talk to a lawyer, because Ms. Harvey's letter makes reference to everything occurred beginning with January 30th of 2018. This so-called acceptance is so convoluted, you can't even tell what she's accepting. Why can't we just affirm on the mere fact that you're arguing that Jessica, a paralegal, waived the contingency of affidavits on behalf of an attorney, that's violative of Florida law. But that was what Miss Harvey was relying on all along, because she testified she couldn't get an affidavit from one of the insureds, because this acceptance that you're calling an acceptance continues to refer to all the conditions found in the first demand. You waived the affidavits. Since your letter didn't include a release, I'm including a release. Well, the letter she's talking about is the January 30th letter, not the CRN.
And Mr. Lord,
Help me out.
Mr. Lord, you can respond to that, but that will need to conclude your presentation after you respond.
Your Honor, I'd say if just for the panel as a whole, is the terms that were posed were as stated in the CRN. That's been complied with. That what the credibility of Ms. Harvey did or did not do has nothing to do, has no bearing on what this appeal is about. The appeal is about the fact that the CRN outlined specific terms, which was complied with when the tender of the $10,000 was done. It's over. The offer's been accepted.
Yeah, but your argument depends on the validity of Ms. Harvey's February 28, 2018 letter, correct? Whether indeed that is a true acceptance, correct?
I dispute that, Your Honor. No, because I'm saying the CRN, which was posed, which Mr. Clark had authority. There's the record saying he had authority to file the CRN with.
But you're saying that's an offer. There has to be an acceptance to get a settlement agreement. So which is the acceptance?
The acceptance is, it's undisputed by Mr. Clark's own testimony that he and his office received the $10,000. Take Ms. Harvey's letter even out of it. It's undisputed by the appellee that they received the $10,000 when the offer was posed. They've gotten it. They've gotten the $10,000. They've acknowledged it.
And Mr. Lord, I think we understand your position. That concludes your portion of the argument. So we will turn now to Ms. Norse. Thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court, my name is Krista Norris, and together with Stuart Markman of Kynes, Markman, and Fellman, we represent Geraldine Taylor. The basic legal principle that governs this case is really not in dispute. It cannot be in dispute, and that is a contract is only formed when the evidence shows a meeting of the minds, which in turn requires an agreement of two sets of external signs in which the parties say the same thing. And I have to point out here that Ms. Harvey, for all intents and purposes, is Progressive, is the company that tried to make this settlement. It's their agent. So we're looking at what she said, what did she do? And in the context of offer and acceptance, that means there must not only be an offer, but there must be a mirror image acceptance that cannot vary from the offer by way of omission, addition, or alteration. And so the insurmountable problem with Progressive's argument is that it cannot point to these two sets of external signs that are in agreement in this case. It wants to focus all of its attention on whether or not the civil remedies notice could be deemed an offer, and then ignore any analysis of its purported acceptance. And the agreement that Progressive now claims is in absolute conflict with what it said in its letter of February 28, 2018 was the agreement it was demanding. So the February 28th letter is the only purported acceptance in this case. It's the one outward manifestation of the terms Progressive said it would agree to. And as noted, it said it was in response to the demand, to the initial demand, to the CRN, and to the filing of the lawsuit, and to the discussion with the paralegal. And that based on all of those four things, that what Progressive said was the agreement was that it was going to pay $10,000 in policy limits, $610 in costs that Ms. Taylor had incurred in filing the lawsuit. And in exchange, Progressive demanded Ms. Taylor dismiss the lawsuit with prejudice and waive any insurance and financial disclosures by Progressive's insured. In fact, Progressive not only said this in the only overt manifestation of its intent, but it later confirmed it in a follow-up letter in March, that these were the terms it insisted on. Those terms are not a mirror image of any offer. They're not a mirror image of the demand. They're not a mirror image of what Progressive now claims was an offer based on the wording of the civil remedies notice. You know, that what it was that they contended below that this was an agreement that they reached with the paralegal, but the trial court found, as a matter of fact, that that did not occur. And so now it's an attempt to reverse engineer, to pluck the CRN from the course of events, to say the CRN is an offer, and then to pluck its own letter and say, ignore all of the stuff in our letter, except we're sending $10,000. But the same rules of interpretation that apply to the CRN or the offer or whatever offer you want to point to apply to the acceptance also. You can't render everything that they said surplusage. That is what they said they wanted to agree to. And again, for the reasons that have been discussed, the CRN is not an offer. No case has ever held it can be an offer. It's sent to a third party. It has an independent legal significance, and it referred to the prior demand. It did not revoke it. But regardless of whether you could even attempt to shoehorn it into an offer, you still have no acceptance according to its terms. You have a very different agreement that is the only agreement Progressive ever said it was agreeing to. In fact, it demanded the dismissal with prejudice. When Ms. Taylor's attorney responded to this February 18th letter and said, you know what, dismissal with prejudice is a problem if I don't have the disclosures, but I'm happy to dismiss without prejudice. And then if you can get me the disclosures, Progressive said, no, deal's off. So they insisted on certain additional terms. They blew the deal when they didn't get what they wanted. And there is no agreement between the parties.
Ms. Norris, I would like to ask a question about the CRN. And your position has been that it cannot be considered an offer. So if a CRN is issued, hypothetically in any case, a CRN is issued and the party that is the object of the CRN complies with what is stated in the CRN, is it your position that the case can still go forward?
I think, I'm not up to speed on exactly all the ins and outs.
Honestly, I'm having some trouble with the idea. I mean, I understand this case has some interesting facts as far as what the CRN related to and talking about the evidence that was presented as to the negotiations and so forth. But I'm troubled by the idea that someone can issue a CRN and say, you're in violation, here's what it's going to take to cure the violation. And if you cure the violation, this case is over. I'm having some trouble saying that can never be an offer, which if accepted, doesn't mean anything. Because that seems to be your position, is that had they accepted the CRN exactly as written by simply tendering the 10,000, that's a so what moment. I'm having some trouble with that.
Right. Well, and I do think that it is an interesting question. If they had said, well, we're interpreting the CRN as an offer and we're doing this. And I don't know that the court has to hold that a CRN can never be an offer, but I would note that no court has ever held it's an offer, and that's problematic to hold it's an offer when, again, it's sent to the department. It's specific.
It's sent to the it's sent to the department with a copy to the object, right? And so, I mean, I'm puzzled by the idea that a CRN, if it is complied with by both parties, that isn't going to end the case if it says it's going to end the case.
Okay. And again, I think that's certainly their argument that you can interpret the CRN that way. In no cases, we have no case on point on that. And I think ultimately it comes down to that regardless of how you interpret the CRN, in this case, you still had subsequent negotiations, subsequent demands. And so I don't think the court needs
those subsequent negotiations and demands seem to me to only be relevant if the defendants in this case didn't comply with the terms of the CRN. And I think your position is that they didn't comply with the terms of the CRN because of the request for a release and because of the discussion in the CRN. I think what you're saying is the prior negotiations are incorporated into the CRN, even though they're not explicitly incorporated.
I think whether they're explicitly incorporated or not, the result is the same, because and I do come back. It is the release. It's not only the release, but the consistent insistence on a dismissal with prejudice, with a release, without any waiver, without any disclosures, et cetera. And that they were offering, additional money to do this. So I think whether or not, really, no matter how you interpret the CRN, you then have to look at if that's an offer, we're still looking at what is the acceptance, and the acceptance is not a mirror image of the offer. So I don't think the court has to go so far as to say, in this case, a CRN can or cannot be. I mean, the facts of this case are unique. The facts are that, there was a reference. The violation that's alleged here is not answering the demand. So to cure the violation, I think at best, you have some ambiguity there. And then all the parole evidence was nobody thought this was a standalone offer. Nobody thought it was going to result in a settlement if they just sent the $10,000. And to then interpret it not only as being a CRN intended to secure this bad faith claim, but then as actually revoking the one thing upon which it is based is problematic at best. I think in the end, it's Progressive's appellate theory that it intended to accept this offer based on the language of the CRN cannot be squared with the evidence of what it said and did. The agreement claimed on appeal cannot be reconciled with the outward manifestations of the agreement the parties went back and forth on. The trial court's finding that no settlement agreement was reached is supported by the evidence and should be affirmed.
Very good. Thank you very much, Ms. Norris. Mr. Lugo, you have 3 minutes.
May it please the court, thank you. First of all, I would like to clear up what I think is a misconception during the argument. The section 624.155 subsection 3A says that the department and the authorized insurer must have been given 60 days written notice to the violation. This is not a document that only goes to the department. This goes to the insurance company as well. When that document was sent to the insurance company, that in the language indicating if you pay the $10,000, then in so doing, that's going to be a full and final release. That was an offer to the insurance company. Now, Talent explains that the purpose of sending it to the department is, quote, and this is on page 1283 of the opinion, is, quote, to assist in the settling of claims and to monitor the insurance industry. So it's not just to monitor the carrier, but it's to facilitate the settlement of the claims. Exactly what was happening here, what the insurance company was trying to do here. Pay the amount, resolve the underlying claim, and settle this case. The second point I want to make is about, I heard some reference to explicit or unexplicit incorporation. Florida law only recognizes explicit incorporation. A mere reference to a document is not enough to incorporate it. It has to state that it is subject to the terms of the prior document or the collateral document, or restate those terms there. And here, the CRN did not do that. It did not ask for affidavits or insurance disclosures, and it did not state it was subject to the prior demand.
Of course, your letter to try to settle the case explicitly references the negotiations and the offers that occurred prior to the CRN. So it does seem to me that the acceptance letter or the tender letter is not accepting any offer contained in the CRN, but it's accepting what was negotiated or attempted to be negotiated in the prior communications.
I understand, Your Honor, but that brings me to the third point I wanted to make on rebuttal, is that this is a case about a unilateral offer. The only way to accept what's in a civil remedy notice, to cure a civil remedy notice, is to actually pay, not to say you're going to pay. What was asked here was the actual tender. The tender was made in the manner, at the time, and in the way that they asked for. That, at that point, there was an acceptance. The cover letter merely indicated what the adjuster was trying to do in the context of the unusual facts in this case, where there were multiple settlement offers on the table. Usually you don't see the civil remedy notice filed while a demand is pending in the underlying action. That created some of the confusion here. The adjuster was trying to comply with all of the demands and make sure that everything was done to settle this case. The fact of what she wrote in that letter does not negate that this is a case about acceptance by performance. Check for $10,000, to Clark and Martino, FBO Geraldine Taylor, was taken to the offices of that law firm within 60 days. That was the acceptance.
Very good, Mr. Lugo. That takes us to the end of the time. Very well argued. Interesting case. We are going to take a 10-minute recess, and then we will continue with the cases on the docket.